Good morning, everybody. Thank you for joining us for this panel discussion on the topic of taking anti-Semitism to court, a legal solution to anti-Semitic harassment. I'm Tal Diamant. I'm the chair of the IAC Council for Colorado, and I'm excited to welcome you to the IAC's 9th National Summit. The IAC builds coast-to-coast community with Israel at heart and has been doing so nationally since 2014 with programs for every age. I hope you're involved with our local activities, and if not, please connect with one of our dedicated team members after this panel. This year, the IAC has formed an Israeli-American party to run for the Zionist Congress elections, aiming to influence next-generation education and Israeli connections. We invite you to join this effort and sign up to vote. I've done so myself, and this is very important if we want to have a voice and if we want to make change. Be sure to grab a copy of the 2024 Community Survey for a deeper understanding of our community. Also, take part of the Unity Survey conducted in collaboration with the Ruderman Family Foundation. The results will be shared at the last plenary session. Please hold all your questions until the end, as we will have time for Q&A following the conversation. Let me introduce our distinguished panel. First, we have Brooke Goldstein, founder and executive director of the Lawfare project. At the end, we have Dr. Mark Goldfeder, director of the National Jewish Advocacy Center. And then we have Alyza Lewin, president of the Louis D. Brandeis Center for Human Rights Under Law. And our moderator is my good friend Joe Sabag, executive director of the Israeli-American Coalition for Action. And before we get started, one little note. I've had the pleasure to work closely with Mark and Joe over the last year and a half to try and introduce a bill that brings the IRA definition of anti-Semitism to Colorado, and they have been invaluable. So please welcome this panel.
Good morning, everyone. Good morning. I'm Joe Sabag. I want to thank everybody for being here. I run IAC for Action, which is a sister organization that works alongside IAC. We've compartmentalized our community's functions in terms of government relations and policy making specifically into this entity. We have three primary functions where we look to engage. Today we're going to be discussing the litigation aspect and how we meet our community's needs by working primarily with organizations that do great work, such as the three organizations showcased here by these professionals on the stage. Secondly, as Tal mentioned, we have an extensive practice operating in the legislating field. I want to note that we're being joined here this morning by Representative Esther Panich from the state of Georgia, who's a fantastic example of the way that our community has advocated and successfully managed to have the IHRA definition codified in, at this point, 14 states. Dr. Mark Goldfeder has often served as a leading subject matter expert in that process. I know that everybody here is concerned about anti-Semitism. I think one of the most important points that we can make here is that our community is making tremendous progress, that we are persevering. The big challenges often require very patient and long-term responses, but those responses are well underway. And then lastly, enforcement. I know in previous years I've been here to talk about the successful cases that we saw in Airbnb and Unilever. So I want the Israeli-American community to know that we are very much on the front lines and that the characteristics that make our community dynamic, just in terms of bringing an entrepreneurial spirit, creativity, and certainly perseverance, those are all things that are embodied by the kind of efforts that we see from these three professionals. The last thing that I just want to note is that the three orgs that are showcased here are relatively young. They're only 15 to 20 years into having been established. So part of what we're seeing here is really something that represents a transition on the part of our community's advocacy from 20th century to very 21st century style advocacy. And these three professionals very much are on the front lines of that. So as the challenges we face continue to evolve, so does the advocacy that emerges from our community. Today we're going to have a conversation about some of the most successful aspects of our community's efforts. I'm going to ask our guests to briefly introduce themselves at the outset of the first question that I'm going to present each one of them. And so, ladies and gentlemen, thank you. Let's get the conversation started. I'm going to start by asking Brooke just to talk a little bit about her background, but also to explain what Lawfare is, understanding that your organization is called the Lawfare Project. Perhaps you can explain to everybody what is Lawfare, why is it so important for our community to be engaged in Lawfare?
Thank you so much for having me. I just want to start out, obviously, by introducing myself. My name is Brooke Goldstein. I am the founder and executive director of the Lawfare Project. I'm also the founder of the End Jew Hatred Movement. If anybody wants a bracelet, you can have one. And I'm really honored to be here with my fellow co-panelists who I admire and who I respect so much. And to be with everybody here, it is so empowering, especially during this time, to have this feeling of unity. When our community is unified, and there's been so many attempts to politicize anti-Semitism, to divide us on political partisan lines, but we are unified. And when we are unified, we can move mountains. And the one thing that gives me, amongst actually several things, but particular to this panel, true inspiration and hope is the unity and the cooperation that we're seeing between the different legal groups now who are engaged in civil rights litigation, impact litigation for the Jewish community. And again, we are 10 years too late to this game because civil rights litigation is as American as apple pie, and we've been doing it for everybody else. We were in the forefront of founding the NAACP. There are Jews for Black Lives Matter, Jews for gay rights, Jews for Asian rights, Jews for Muslim rights. The time is now Jews for Jewish civil rights. And so to answer the question briefly, what is Lawfare? Lawfare is a term of art that was reintroduced, I think in the late 80s, early 90s by a gentleman named Major General Charles Dunlap in a Harvard Law Review essay. And I want to emphasize something. It is an inherently negative term. It means the use of the law as a weapon of war. It's the abuse of the legal system. That's not what we're engaged in. We are engaged in the pursuit of justice, in using the legal system to enforce the civil rights of the Jewish people to equal protection under the law, regardless of what's happening thousands of miles away. The more that we respond to to anti-Jewish discrimination with pro-Israel advocacy as opposed to civil rights advocacy, the more we're playing into their affirmative defense. Well, I hate Israel, therefore I can treat you differently because you're Jewish, and that is wrong. And so language is everything, and we need to describe what we're doing as the pursuit of justice. And the Lawfare attack against not just Israel, but every Western democracy, because the precedents that you set in international law against Israel, a democracy fighting on an asymmetric battlefield against terrorists that are using their own children as human shields, those precedents can and will be used against the United States. They can and will be used against other Western democracies fighting against the same terrorists with the same theological motivation, not just to kill Jews, but to kill all infidels. So, I've been very vocal that the response by the Israeli government, for example, to the ICJ, I thought was a mistake. The fact that the ICJ, never mind a couple of years back, issued an advisory opinion that the Israeli security fence, the border that we set up, is a violation of international law. This is the same court that refused to enter into evidence the very relevant fact that the fence contributed to a sharp decline in the loss of human lives, that refused to hear the testimony of Jewish, Muslim, Christian terror victims. This Lawfare court, for some reason, we decided to send Talbecker, who's an incredible orator, an incredible attorney, to go appear before this kangaroo court, these judges in their ridiculous wigs, to stand judgment over the Jewish people, the Jewish state. And we have to answer to no one when it comes to our right to self-defense. We've earned the right to self-defense, and we've gone above and beyond what is required by the laws of armed conflict. And so I will conclude with saying that it's so important that we don't play into these lawfare attempts, the war crimes charges issued against Israeli officials, while Hamas and Hezbollah and the Muslim Brotherhood are free to cross European borders with impunity. But Israeli generals are facing arrest warrants. That is lawfare. That is the abuse of the law as a weapon of war, because they know that they cannot defeat Israel on the battlefield. We are undefeatable on the battlefield, but they will try through media warfare, through legal warfare, through political warfare, through what's happening with OFAC right now, which I'm sure you'll talk about. That is lawfare, and that is what we are fighting against.
Alyza, you started to become very well known, particularly within the Israeli-American community, about 15 to 20 years ago through your handling of a case called Zivotofsky. I'm certain that we have quite a few American citizens here who were born in Jerusalem. Maybe you can tell us just a little bit about that case and how it began to shape your career within the advocacy space.
Sure. Thank you, Joe. And it's also a pleasure, as Brooke said, to be here and be with my friends on this panel. So I now, my name is Alyza Lewin, and I'm president of a nonprofit organization called the Louis D. Brandeis Center for Human Rights Under Law. That's a nonprofit that uses legal tools to combat anti-Semitism. We are not connected to Brandeis University, totally separate nonprofit. But before I came to the Brandeis Center, as you said, I have a law partnership with my father, and we brought the Zivotofsky case, which has also been known as the Jerusalem passport case. And so particularly if you have a child born in Jerusalem and you're an American citizen, this case has particular personal relevance to you. But it has relevance, quite frankly, to the entire Jewish community and Israelis in particular. Because many people don't realize, and we heard President Trump last night talk about how he recognized Jerusalem as the capital of Israel and the Golan Heights as being in Israel. But people don't realize that up until 2017, when President Trump recognized Jerusalem as the capital of Israel, from 1948 until 2017, the official position of the United States government was that Jerusalem is not in Israel. And we're not talking about east or west. We're talking about all of Jerusalem, east and west. This was initially out of deference to the partition plan in 1947, the idea of Jerusalem being a corpus separatum. And so you could see that this was the policy most clearly when it came to the passport rules. Because the United States government passport rules say if you have an American citizen who's born abroad, outside of the United States, then the rule is that the US passport for that citizen lists their country of birth, only their country, not a city. So if you had an American citizen born in Tel Aviv, for example, their US passport would list Israel as their place of birth. Born in Haifa, it would list Israel. But if you had an American citizen born in Jerusalem, the rule was Jerusalem has no country. So the US State Department would put Jerusalem on the passport instead of Israel, because Jerusalem's a city with no country. And it didn't matter if you were born in West Jerusalem, no difference. It still would only put Jerusalem. Now, the policy actually would give a wink and a nod and accommodate those people who felt that maybe someday Israel wouldn't exist. So if you were, for example, somebody born in Haifa, perhaps an Arab-American citizen born in Haifa, who had Israel then listed on their American passport, and you didn't like that, you could ask for Israel to be removed from your passport, and the State Department would accommodate that, would go against the rule, and would put the city on. And in fact, if you were born anywhere in Israel before 1948, it could be Tel Aviv, Haifa, Beersheba, Jerusalem. If you were born before 1948 and you wanted your passport to say Palestine, the State Department would list Palestine as your state of birth, as your country of birth, even though the rule is that you have to list the current sovereign. So for example, I know someone who was born in Kiev when it was part of the USSR. His passport lists Ukraine as his place of birth, because now that's under Ukraine's sovereignty. But for those who want to put Palestine, they would go against that rule also. So in 2002, Congress actually passed a law that said that if you're born in Jerusalem and you request it, the State Department shall list Israel as the place of birth on your passport. But the State Department refused to follow that law because when President Bush signed that bill into law, and it passed overwhelmingly through Congress, it was part of a bigger law, and he issued a signing statement saying, this small section of the law, we're not going to follow it. Why? Because he said it impermissibly interferes with my ability as the president to engage in foreign policy. And he said Congress doesn't have the authority to make the executive branch put Israel on the passports. This became a major separation of powers question. Who has this recognition power? Is it Congress or is it the president? The case went to the Supreme Court, the US Supreme Court, twice. My father argued it the first time. I ended up with my first Supreme Court argument. That was his 28th argument. Mine was the second time around I argued, it was my first argument. The truth is, even though we should have won that argument, we lost. All 3 Jewish justices ruled against us, and I'm convinced that the reason is because they were afraid the executive branch had told them, if you put Israel on the passport, World War III will break out and people will die. Everybody legally, in terms of the legal arguments, was on our side. We had all 100 senators. I don't know if you can imagine all 100 senators agreeing on anything today. All 100 senators filed an amicus brief, additional congressmen, state attorneys generals, legal scholars, the whole Jewish community from right to left. There were 3 briefs filed against us. One was from the Arab American Anti-Discrimination Committee, which finally, after 13 years, filed its first brief. The first time we were in the Supreme Court, we said they don't even care about this issue. They've never filed a brief, so the last time around they filed a brief. Then there were the True Torah Jews, Neturei Karta, who opposed the existence of the State of Israel. And then there was a disgruntled taxpayer in California. That was it. And so legally, we should have won this case, and yet we lost. And the court turned around and said, look, you can't force, Congress can't force, the executive branch should talk out of 2 sides of its mouth. If you're going to put Israel on the passport, it looks as if the State Department is saying Jerusalem's in Israel. But we know, and they didn't give this example, but I'll share it with you, this was during the Obama administration. And so when President Obama gave the eulogy for Shimon Peres on Mount Herzl in Jerusalem, right, this is the Arlington Cemetery of Israel in an area of Jerusalem that's been under Israel's control since 1948, when the White House issued his eulogy, the first time when they sent it out, it had the tagline, Mount Herzl, comma, Jerusalem, comma, Israel. And a few hours later, the White House sent out a corrected version of the eulogy. The only correction was a line strike through the word Israel, as if to say that Mount Herzl's not in Israel. It's in Jerusalem, but that may not be Israel. So how could you force the executive branch to talk out of 2 sides of its mouth? And then the court went on and said, and you know what, we're going to decide, even though this was not at all clear from the history, that the President of the United States has the exclusive authority to recognize foreign sovereigns. That was during the Obama administration. Nobody anticipated a president like Donald Trump. And then along comes President Trump and recognizes Jerusalem as the capital of Israel and the Golan Heights as being in Israel. And I will tell you, I don't know how many of you are aware, but when it came to President Trump, it was almost like a cottage industry. Every single thing he did, there were lawyers that ran into court to file for injunctions to block whatever he did from having any kind of impact. It could be taxes, health care, immigration issues, how to run his own hotels. I think there were probably hundreds of lawsuits that were filed. There were zero lawsuits filed challenging President Trump's recognition of Jerusalem as the capital of Israel or the Golan Heights as being in Israel. And the reason for that is because in our case, the Supreme Court of the United States had decided that the President of the United States has the exclusive authority to recognize foreign sovereigns. So President Trump was exercising a power that the Supreme Court had already recognized. He had the exclusive authority. He was the only one who could do that. So there was no way to undo what he did, which is why, if you look at now when people started to question what would happen with the Golan Heights, with the Biden administration, if you listen to the early conversations from Secretary of State Blinken, he says, well, putting the legality aside, that's because the legality is, unless, and I'll tell you, the rules used to be, until President Trump, that if you had an American citizen born in the Golan Heights, they were to list Syria as their place of birth on their US passport. And that was changed with President Trump. So now a baby born in the Golan Heights, it lists Israel on their US passport. And if you're born in Jerusalem, you can now have Israel put on your passport also. And in 2020, Ambassador Friedman gave our client the very first US passport to officially list Israel as a place of birth on the US passport.
So I would just comment and contradict you slightly in saying that the case didn't actually result in a practical loss. I think that in the legal sense, perhaps it can be considered that way, but I know that Alyza's great work was one of the most practical contributions to bringing the issue into focus, and in part to bring it to the attention of President Trump and leading to that practical outcome.
It made me realize, quite frankly, that you never know. First of all, never ever give up, and sometimes what you think might be your greatest defeat can turn into your greatest victory.
100%. Mark, I'm going to turn to you now. I know that you've been here in Washington, D.C. for a few days, and on Tuesday, in fact, you appeared once again in front of Congress. You spoke to the Senate Judiciary Committee. I know you talked a lot about the issue of anti-Semitism and then offered a variety of legal and public policy-based considerations for the Senate to consider. Can you talk a little bit about that appearance that you made? I know many folks in the audience may have seen some of the sound bites. We thought you did a fantastic job advocating on behalf of the community. Tell us about that experience and some of the public policy considerations that the Judiciary Committee had you hash out.
Sure. Good morning, everybody. My name is Mark Goldfeder. I'm director of the National Jewish Advocacy Center. It is an honor to be sitting on the stage with heroes like Brooke and Alyza, and I also want to take a minute to acknowledge that Joe Sabag, our moderator, has probably done more than any person alive to pass legislation across the country protecting our community. If you did watch the hearing, you might have seen that it got a little bit political. And the first thing that I wanted to do when I spoke was to explain why, in a hearing that was essentially about all hate, I was focusing on anti-Semitic crimes in particular. And the reason is because Jews are often the canary in the coal mine of intolerance. What starts with the Jews never ends with the Jews. This time, it did not take very long for the chance to morph from death to Israel to death to America, and they went from desecrating menorahs and vandalizing Hillel houses to defacing the George Washington statue and painting over the Freedom Bell. So it is important to realize that stopping anti-Semitic hate crimes is a matter of self-preservation for all Americans, because even if you're not Jewish, they're coming for you next, and they're not shy about it. You can ask them. And so what I tried to do was explain that, yes, there are problems, but there are also solutions. The first thing we said is, look, please, Congress, use your oversight powers to ensure that the laws are actually being enforced as written. That includes, of course, Title VI of the Civil Rights Act of 1964, but it also includes laws like the Immigration and Nationality Act, which say that, look, if you're a foreign student and you're trying to provide support to a terrorist organization, you have to go. And unfortunately, the government has not yet wanted to do that. Now look at what they're handing out on college campuses today. These are actual Hamas recruitment materials that they're handing out at Columbia University. Inside the gate, by the way. Some of them have argued that it was outside the gate. This was handed out inside the gate. Pledges to the PLO and to Hamas. Okay, that violates the Immigration and Nationality Act, and those people should be deported. Number two, there's new legislation that we should consider, including the Anti-Semitism Awareness Act, which adopts the International Holocaust Remembrance Alliance, the IRA, definition of anti-Semitism. I'm sure we'll talk a little bit more about that, but a key point of the hearing was to note that although there is a fringe minority, even within the Jewish community, Jews are not monolithic, that doesn't support this legislation, over 90% of American Jews wholeheartedly support the bill, and what I tried to tell the senators was 90% is more than a consensus, it's a mandate, and it's something we really need to do.
Mark, thank you. Brooke, I'd like to ask you to talk just a little bit about how the Lawfare project has been able to observe this dramatic increase in anti-Semitism simply by looking at, the sheer volume of cases and the type of cases that are now coming in through the door, where we have just too many victims seeking support at this time. Just talk about how you have a unique view of that increase.
So the Lawfare Project is a public interest law firm as well as litigation fund, and we have a network of over 800 lawyers and work with over 37 major international law firms, and we've brought, I think it's now over 152 cases in the last 7 years in 16 different jurisdictions around the world. And one of the questions that I keep getting asked when I go on television or I do speaking engagements like this is, well, are you surprised? Are you surprised at the level of Jew hatred and anti-Semitism that has become now prevalent after October the 7th? And my answer is always no. I'm not surprised, because people like me and, my colleagues here have been warning about the radicalization that is happening on college campuses, the marriage between this Marxist and Islamist ideology. We've been talking about the billions of dollars, $1 billion a year from Qatar that we know of for at least the last 10 years, feeding into our institutes of higher learning and also K through 12, influencing how critical race theory is taught, how the DEI departments are applying their rules and regulations. And we've been talking about radical Islam. And yet anybody who was speaking or writing or even joking about the very real national security threat that theologically motivated radicalism and terrorism poses, not just to the Jewish state, but to America and all Western democracies. Anybody who was talking about this was called Islamophobic, was called a racist, was called a bigot, was sued. Recall when 17 media defendants were sued by the Islamic Society of Boston after they wrote and spoke out about the fact that Saudi funds were coming in to the Islamic Society of Boston, radicalizing their mosque goers, and they were shut up. Because when you're in the middle of a defamation lawsuit and you're on the defense, your lawyers are going to tell you to be quiet. And what happened? The media stopped reporting about it, and the Boston bombers, who were allegedly radicalized at ISB, blew up at the marathon. And you wonder, if people felt free to speak about these issues, would we have seen that terrorist attack? If members of the Jewish community who were calling out radicalization on campus were supported by the big box Jewish organizations, would we see the protest and the rampant discrimination that we see right now, the pro-Hamas radical protests that are blocking Jews from entering their classrooms, that are creating Jew-free zones illegally on campus? Would we see it happening if we had an organized, communal, strategic, legal offense and did not try to intimidate and silence ourselves? I mean, I remember in 2011, when a year after I founded the Lawfare project, I got a phone call from the CEO of a now defunct major Jewish organization. And he was yelling at me, saying, "What are you doing? Who do you think you are, bringing a lawsuit? We're engaged in negotiations with these schools. We're working on your behalf, working on the students' behalf, no matter the students are the ones that came to us for support and representation. We're negotiating behind closed doors, behind the scenes, and your lawsuit is messing that up. And you're too aggressive. And you are creating anti-Semitism by feeding into the narrative that we're too litigious and we're moneyed up." And I thought to myself, well, could you imagine the black community accusing the NAACP of too aggressively fighting to assert the civil rights of the black community? And so I'm very pleased to see that, I guess, and I hate this term, but the silver lining after October the 7th, besides the unity, is the community waking up to the power of impact litigation. And it's something that my colleagues here, and certainly Alyza and Mark, have known for quite some time. Because the way that you enforce change in a liberal democracy is not through violence. It's through the legal and legislative systems. And we must continue to bring Jewish civil rights cases on behalf of those who have been unlawfully discriminated against. And we're seeing, obviously, a rise in those cases. I just want to mention one thing. We have filed a lawsuit against the Council on American Islamic Relations for defaming our client, Tamar Herman. CARE is a Muslim Brotherhood Front organization, an unindicted co-conspirator in the Holy Land Foundation trial. They were at the forefront and still are at this BS political correctness I call the Islamophobia mania campaign, because it's insane. And they had the chutzpah to falsely accuse our client, Tamar Herman, of purposefully ripping off the hijab of a 7-year-old student and saying something like, "Your hair is prettier when it's not covered." Obviously, this was a lie. She was defamed, she was slandered. If you Googled Tamar Herman's name after CARE came out and defamed her, for pages and pages of Google, New York Times reports, major mainstream media publications, Tamar Herman accused of ripping off the hijab, created anti-Semitism. She got threats of violence. She had to move out of her home. Well, we've turned the tables now. We sued CARE for defamation, and we are going to win, because what they've done is disgusting and false and defamatory. And I'm pleased to see now that the big box organizations and the medium organizations and the legal community and the Jewish community are now solidly behind these legal efforts. Because if we don't stand up for our own civil rights, who's going to do it for us? And we have to demand allyship from all the other minority communities that we've stood for, that we've marched for, that we've set the legal precedents for.
Absolutely. Thank you, Brooke. I know that there's a lot more that can be said about CARE, because I know each one of us have squared off against them in one context or another. Alyza, I know we were facing them in their attempts to try and tear down many of the anti-BDS laws that we've created around the country. Mark, we're going to talk in a moment about the case that they've brought against the executive order that you helped to facilitate in Texas. But I'm going to ask Alyza now to talk about a very recent victory that she was able to achieve on behalf of our community, something which is very difficult for me to overstate the importance of, and that is now in having Zionism officially recognized by the U.S. justice system as being a key component of Jewish identity. Alyza, I'd like to ask you to talk a bit about this victory and to explain its foundational importance to the community's efforts now moving forward. What's the meaning of all this, and why is this just so important and groundbreaking for us?
Sure, thank you. And I want to build on what Brooke said in the answer to that. I also want to say, in addition to the Lawfare project, one of the things when you talked about how many people needed the assistance, particularly after October 7th, the Brandeis Center was also like Lawfare project. It was totally flooded. We had a 10-fold increase in terms of the requests for support and assistance. So one of the things that we did do is we created, together with the ADL and Hill International, what we call our Campus Anti-Semitism Legal Line, our call line, where students, and we've expanded it now to also include K through 12, can reach out to our legal-protection.org, and we trained over 250 lawyers initially. We're now over 350 volunteer lawyers to do that intake, and we review each and every one of those intake memos to help determine the next steps. And those next steps, and to answer your question, could be just advising students in terms of their communications with administrators. It could be filing administrative complaints with the Department of Education, or potentially, if they're serious enough, reaching the level of federal litigation. But let's talk for a minute about this Zionism as an integral component of Jewish identity. As Brooke was saying, I think one of the greatest challenges we face today is getting the world to see the actual harassment and discrimination that Israelis and Jews are experiencing. It's being masked as if it's a political debate. It's not a political debate that is taking place on campus. When students are being blocked by an encampment from getting to the library or the dining hall, nobody's asking them, what's your position on Netanyahu? What's your opinion of a two-state solution? They just see the Magen David, they hear them speaking Hebrew, they see a kippah, they say, you're not welcome. Not only are you not welcome, you are the equivalent of evil. And as Brooke was saying, for years on campuses, we saw this building up, right? We saw the kind of simple equation of Star of David equals Zionist equals whatever that evil concept is. Apartheid, colonialism, ethnic cleansing, genocide, famine. They weren't offering those terms for people to try and debate, is it really apartheid? Is it not apartheid? No. They were offering those terms specifically because they wanted that equation to sink in, that the Jew equals evil, period. And in fact, when Jewish students would try to engage, but they'd want to talk about the policies, let's try and figure out if there's a way forward to peace and coexistence, the answer was inevitably anti-normalization. We won't even talk to you. In fact, we're going to boycott those pro-Israel Jewish organizations. We're going to have nothing to do with them, right? Because this is not about a political debate. And what's unfortunate is, if it were a political debate, if it were rational, then you could try and negotiate a rational political solution. But anti-Semitism is not rational. Anti-Semitism is an irrational hatred. And it's very hard to accept and to recognize that there may not be a way to negotiate a resolution to the anti-Semitism. And what the issue, though, is we need to make sure that we're protecting our students from the anti-Semitic harassment and discrimination. And the problem, and I saw this when I came on board at the Brandeis Center 7 years ago, is that the administrators on these campuses were completely missing the truth of what was happening on their campus. And our Jewish organizations were inadvertently making the situation worse. Because what was happening is you had these groups that were spewing the horrible, distorted anti-Israel narrative, and the organization said, oh my gosh, we have students who have come to campus, they don't know Jewish history, they don't know Israel's history. We have to give them the facts. We have to give them Israel's narrative. And so they prepared all the nice little booklets and the talking points, and our students were wonderful. They went out there and they dutifully put out the pro-Israel narrative, and it did nothing. Nothing. Because the hatred was coming from folks who didn't care. They weren't about to engage. But the only thing that it did is it reinforced the mistaken impression for the administrators that what they were watching was a good faith political debate, because now it really looked like you had two sides, a pro-Palestinian side, a pro-Israel side. And so their feeling was, we're not going to say anything. We're not going to pick a side. We're not going to silence any speech. Now, in terms of the law, what has happened is our most effective legal tool, and the law is a very powerful motivator, as Brooke is saying, is Title VI of the Civil Rights Act. And what Title VI says is that if you're going to get federal money, that money comes with strings attached. And you have to make sure as a university that everybody on your campus has equal access to all the opportunities, academic, extracurricular, all of them. And so if you have groups that are being shunned or excluded or marginalized or harassed so intently that they can't get that same access, they don't have the same opportunities, the universities are at risk of losing their federal funds. The problem is, Title VI doesn't include religion as a protected category. So how are you going to protect Jews? The answer is that 20 years ago, in 2004, the founder of the Brandeis Center, who was then the head of the Office for Civil Rights in the Department of Education, set out what's become known as the Marcus Doctrine, which is that if you are a member of a religious group and you're being targeted on the basis of your shared ancestry or ethnicity, then you're covered by Title VI. And so the question then becomes, well, what's the Jews' shared ancestry and ethnicity? And the answer is, it's our Zionism. Because the Jews are not only defined as a faith, we're also a people. And you have many, many secular Jews in the United States, around the world, and in Israel, who do not define their identity by religious practice. They define their identity as part of a people. And what defines our peoplehood is our shared common history, our shared common heritage, right? We have that Passover Seder because we're all descended from the people who were once slaves in Egypt. And so our shared history, our ancestry, is inextricably intertwined and rooted in the land of Israel. Today, if you say that, if you say, I define myself as part of a people indigenous to the land of Israel, you are treated as a pariah on campus. You are told you are not welcome. You are told you are the equivalent of evil. And you are pressured to hide or shed that part of your identity in order to engage. That's the discrimination, right, that we need to, in terms of bringing forth a Jewish civil rights movement, that's the discrimination that we need to highlight. And in order to do that, we had to both teach students to talk about this as an integral part of their Jewish identity, but also make sure that the entities that are reviewing these complaints recognize that. And so we have had now cases before the Office for Civil Rights where they have recognized this kind of anti-Zionist harassment and discrimination as a form of what they call national origin discrimination on the basis of shared ancestry. And we're now working in federal cases against UC Berkeley, against Harvard and others, to enable the federal courts to make that same recognition. But it's essential that we as a people all start talking that same language and making it abundantly clear, because I will tell you, and with this I'll finish, there is now an effort on campuses to seriously erase and deny our identity as a people with an ancestral connection to Israel. I kid you not, the scholarship on campus today says the following: everything that happened in what we call the land of Israel, since creation, they say is Palestinian. They say, yes, there were Jews, there were Muslims, there were Christians in this country, but those are just faith-based identities. They say the cultural, ethnic identity of all those people is Palestinian. That's how you get the notion Jesus was a Palestinian. And what they now say is, if you push back against that narrative, you are now racist. They call it anti-Palestinian racism. They say we know the difference between the Jew and the Zionist. The Jew recognizes that Jews are just a faith, but the Zionist is the one who they say is erasing our Palestinian history and heritage by calling it Jewish. The chutzpah. They take our history and heritage, call it theirs, and then when we claim it, they call us racist. We have to push back fiercely and forcefully against that and make it very clear that we are all part of a people, the Jewish people, and we are indigenous to the land of Israel, and that's where our right to self-determination in that land comes from.
Alyza, I think that on behalf of the Jewish people, it's important for me to simply say thank you for everything that you're doing in this process. Mark, I want to pick up the pace just a little bit because I know there are just too many interesting things that all of you are involved in. I want to ask you just very quickly, since you're very frequently getting up to articulate the importance of IRA to the Jewish community, can you briefly just summarize why do our opponents hate this definition so much? And then I have a follow-up question for you.
Sure, there's a lot of layers to that question. The first thing is because the IRA definition is good, and most of the Jewish people recognize that it does a good job of describing our shared lived experience of how anti-Semitism manifests. The way that it does that is it's a praxeological definition, a conduct-based definition. So it focuses less on the reasons why people hate Jews and more on what exactly Jew haters tend to do in real life. And that's important because there are so many shifting rationales for why people hate Jews. They're too rich, they're too poor, they're too weak, they're too strong, they're superhuman, like in the Protocols of the Elders of Zion, or they're subhuman, like in Nazi ideology. It makes no difference. And so if you want to actually protect Jews, you need a solution that cuts through the timely rationales that are given for a timeless hatred. And the IRA definition does that best with the use of its examples. Now, the reason we need IRA legislation is this. Because Jewish identity, as Lisa was saying, is so multifaceted, without a standard definition for a lawmaker or an authority to reference, it is too easy for an anti-Semite to commit horrible acts against Jewish people and then claim it wasn't anti-Semitism because it wasn't based on this or that particular characteristic. And so acts like the Anti-Semitism Awareness Act remove that ambiguity by requiring the authority to consider as contextual, rebuttable evidence the world's only gold standard international definition of anti-Semitism. And they hate it because it's effective. It's the only definition ever that has a 20-year track record of actually curbing anti-Jewish hate. And so it's incumbent upon all of us to push for its adoption.
Yeah. So I know, Mark, we're seeing the intersection between the legislative process and litigation in Texas right now. I know that just last year we were successful in helping to prompt Governor Abbott to go ahead and issue an executive order that did just what you explained. And I know I think 3 or 4 weeks ago, IAC was proud to sign on to an amicus brief led by National Jewish Advocacy Center, which you took the lead in drafting. Because CARE has brought a challenge to that executive order in the Fifth Circuit. Can you talk a little bit about that case and the implications?
Sure. It's building on what I think both Brooke and Alyza are talking about. We're seeing a slurry of retaliatory complaints across the United States. And so what I mean by that is this. Every time a Jewish student complains of anti-Semitism, the other side is told to file 2 complaints. One for Islamophobia and one for anti-Palestinian racism. How many of you have seen an anti-Palestinian encampment? You haven't, because they don't exist. They don't exist. And yet, if you read the complaints, you'd think that there are twice as many anti-Palestinian encampments. And the reason is because if you think taking down an encampment that is pro-Hamas is somehow both Islamophobic and anti-Palestinian, you get double the complaints. And that strategy worked so damn well at the administrative level that even the White House was echoing those numbers. A 300% increase in anti-Semitism magically became a 600% increase in anti-Islamic incidents. And so what CARE decided, and credit to them for trying, is let's try this in court. And so they filed a lawsuit in Texas saying that how dare Governor Abbott stand up for Jews, that is Islamophobic, and how dare he take down a pro-Hamas encampment that literally threatened violence, that is anti-Palestinian racism. And we tried to explain to the court that's asinine.
I want to just point out to the community that we've certainly squared off against CARE, and they often partner with the ACLU. In fact, from 2017 until 2023, they had brought 6 major test cases trying to tear down anti-BDS laws across 5 circuits. I would simply like the community to know that those challenges are no longer existent at this point. There are no federal challenges to those anti-BDS laws, and with the help of many of the attorneys on this stage, we went undefeated in that process. Brooke, I want to talk briefly about the experience of plaintiffs who have to make the decision to step forward, some of the consequences they know that they're going to suffer by stepping forward. Can you talk us through what are some of the considerations for somebody who has to make a really brave choice to go ahead and put themselves in the spotlight in this process? Sure. Can you talk about that experience?
Yeah. So before I answer that, I just wanted to make a comment about what Mark said. This whole narrative of what is anti-Muslim or Islamophobic, it's more than asinine. It really betrays who they are. In 2006, I co-produced a movie, a documentary film, which ended up winning the Audience Choice Award for Best Film, ironically, at the United Nations Documentary Film Festival, for which I risked my life for 2 years. I was embedded with Hamas, Islamic Jihad, the Al-Aqsa Martyr Brigades, and Fatah. And I secured firsthand interviews with leaders of these terrorist organizations admitting they recruit children for suicide, homicide missions. They use children as child soldiers and as human shields. I released the movie. We won the award. And when I went, I traveled for a year doing film festivals around the world, and I was accused of being Islamophobic. I was accused of being anti-Muslim. And I thought to myself, I was 27 years old, I thought, well, if risking your life to raise awareness about crimes against Muslim children, if saying that Muslim children deserve human rights protections is anti-Muslim, what then is pro-Muslim? And doesn't that betray your bigotry of low expectations, this whole moral equivalence stuff? And then the second thing I wanted to say is there's such a beautiful interplay and interaction between the attorneys and the lawyers, that the cases and the precedents that we're setting. And what Mark is doing right now is creating a database that's powered by AI to track these cases. Now, back in 2019, the Lawfare project entered into a settlement agreement with San Francisco State University and with the California State University system. And at that point, the SFSU denied Hillel, the only Jewish group on campus, the ability to table at a student fair. And they did so because they said this is a Zionist-free zone. And to answer that, we said, well, obviously, who are you to define what Zionism is for us? Zionism is an integral part of our Jewish identity, and so on and so forth. But, and this was the kicker, only the Jewish students are given a political litmus test before they're allowed to participate. You don't go to the Muslim Student Association and say, well, are you pro-Iran deal or anti-Iran deal? And unless you're a good Muslim, you can't table here. You don't go to the Black Student Association and say, well, what's your opinion on, what's happening in Sudan? Only the Jewish students are asked what their political opinions are, if they're pro-occupation, anti-occupation, pro-Bibi, and to denounce their ethnic identity before they're allowed to participate. And that is de facto discrimination. It was because of this argument we were able to enter into a groundbreaking settlement in 2019, where for the first time ever, a government entity, the California State University system, recognized, quote, Zionism is an integral part of the Jewish identity of some Jewish students, end quote. Therefore, anti-Zionist discrimination, and we keep repeating this, and I think we have to repeat it, is a civil rights issue. It's not a political issue. So really, really briefly to what you asked, I can't tell you how many times, and I'm sure my colleagues share the same frustration, that we're getting these calls from Jewish students who are being beaten up, they're being discriminated against, they're being denied equal access to school facilities, they're being harassed, and they're afraid of retaliation if they stand up for themselves. There's this, I think Noah Tishby calls it the epigenetic fear of standing up for yourself. There's nothing to be more afraid of. If you are being discriminated and beaten up and harassed and you don't do anything about it, that's what you have to fear, is that this will continue without consequences. You know, a lot of people say to me, well, how are we going to end Jew hatred? Jew hatred is, a staple, and the Torah says in every generation they'll rise up against us. And everyone's born with this emotion of hatred. But Jew hatred is taught. And when we say ending Jew hatred, what we mean is imposing consequences for behavior we don't want to see, right? Harvey Weinstein, by no means the only male misogynist in the world, all right? And the Me Too movement did not get rid of male misogyny, and Black Lives Matter did not get rid of anti-Black racism. What they did is they imposed consequences. They picked a target, Harvey Weinstein, and they went after him, and they took him down to set an example, and now nobody wants to be like him. What my colleagues and what we're doing here are setting consequences, ensuring consequences in courts of law for behavior we don't want to see. And that's why I'm very proud of people like Jake Mandel, who was the lead plaintiff at San Francisco State University, who was so brave at 17 years old to sign on to our lawsuit, even though when his own community was discouraging him to do that. I am proud of our client, Jonathan Carton, who was the first ever Jewish student to file an OCR complaint after Trump also expanded Title VI of the Civil Rights Act to include Jews, to include the Jewish religion and to include the Jewish identity. He was the first ever student to file an OCR complaint under Title VI using Trump's executive order. And because it was Trump, the Jewish community came out against him. Now, if President Obama moved the embassy to Jerusalem, I would be first in line to congratulate him, because we have to push back on the politicization of anti-Semitism and Jew hatred. And so what I encourage anyone to do is call the hotline. If something happens to you, go to our website, thelawfareproject.org, click Get Help. If you're a student or you're a professional, we work with tech professionals, we work with hospital, with doctors, with anyone who's experienced discrimination. And take advantage of the resources that we have set up for you here. We have our incredible attorneys. We have the funds, we have the means, we have the resources. The truth is on our side and the law is on our side. So please, please encourage people to take advantage of that.
If I could just say, it is possible to engage in these kinds of cases and maintain anonymity. So the Brandeis Center, for example, is a membership organization, and one of the things that we have done both with administrative complaints and with federal court cases is the students join the Brandeis Center, they sign up, it's free, and then the Brandeis Center becomes the plaintiff representing the interests of the students, and the students' names do not have to become named plaintiffs in a lawsuit if they are not ready or comfortable to do what some of the Lawfare Project's clients have done.
Friends, our time is coming to a close here, so I'm going to just cut to one last point I'd like to make, since we're not going to have time for additional moderated questions for the panel. Every single one of the talented attorneys on this stage spends a significant amount of his and her time mentoring young attorneys. So I know we have a number of law students who have come to join us here at the conference, and that many of you, in fact, may be parents of law students. I think that in this generation, we're going to find it's increasingly important for us to raise very high quality advocates. Perhaps we won't have the numbers, but we definitely need to have the quality. And so, each one of the professionals on stage here makes certain that we have young professionals, either law clerks who are finishing up and preparing to take the bar and move into their professions, and otherwise we spend a lot of time making sure that we're cultivating the next generation of advocates. I know Mark has a closing word on that.
Yeah, I'll just say this. One thing that we have to learn how to do better is to learn from our enemies. They do two things really well. The first is coordination, and as both Brooke and Alyza talked about, we're doing a good job of working on building that. NJAC, for example, launched recently the Institute for Litigation Coordination. As Brooke said, we're tracking every single anti-Semitism case in the country. We have AI that searches for cases that weren't even coded properly, and we share all that information with our 17 now partner organizations so that everybody has at least a basic understanding of the litigation and legislation landscape of anti-Semitism in America. But the second thing we're doing, the other side does really well, is they execute on 20-year plans. And we didn't have a 20-year plan in place. And one of the things that they did was they spent 20 years training advocates, and they now have better lawyers than they used to. And so in order to combat that, actually the National Jewish Advocacy Center has partnered with Touro University to launch the first ever anti-Semitism law clinic. The first cohort began just 3 weeks ago, and in January, it's going to be operating out of Times Square. There'll be the first ever anti-Semitism law clinic to train the next generation, really give them the practical hands-on experience for not just for our organization, but for all the organizations, that there's a talent pool, and that in 20 years, we do 10 a year, there's 200 other attorneys who can be on this stage.
I will say also that the Brandeis Center has not only opportunities for law students to work with us. We've been running what we call our Jigsaw Fellowship, our Justice Initiative guiding student activists worldwide, where we have a curriculum that we teach law school students and then pair them and have them work with the undergraduates to try and help provide them with the support and the guidance and the mentorship that the undergraduates, because sometimes undergraduates are too intimidated to talk to lawyers, but not to law students. And the idea was the same goal as Mark is describing, which was to actually train these law students to understand the specific areas of law you need to effectively combat the anti-Semitism on campus. The First Amendment issues, the anti-discrimination laws, the international law issues related to Israel, the principles of academic freedom, these things. So if you have law students, also, if they don't go to that clinic, they can come sign up as Jigsaw Fellows.
And Lawfare Project is hiring. So if anyone wants a job doing this, if anyone wants to get paid litigating on behalf of the Jewish community, come and talk to me.
Yeah. Friends, I want to thank everybody for joining us this morning. I want
The
to thank
making
our
of a
panelists.
martyr. Thank you.
I want to just mention that tomorrow morning, IAC for Action Chairman Sean Evenheim is going to be having a discussion with leading legislators, state legislators from around the country. So I wish everybody a Shabbat Shalom and hope to see you tomorrow morning at 9:30 here in the same room.
Thanks, Joe. And before you leave, please try and use the QR code on the side for a survey. Thanks for joining us. Enjoy the rest of the day.